Hello, everyone. My name is Rhodes Donald. I'm an advisor with Paulson Higgs Wealth Management. And today I've got Derek McLaughlin from Galloway Cook Allen with me. And Derek's a resource management lawyer. And I've asked him to talk about some of the water issues facing farmers in Otago, but also Southland and Canterbury as well. They're not the same. They have different environment plans, but the issues are similar. So, Derek, as a resource management lawyer, what kind of work do you do and who employs you?
Well, at the moment, what we're seeing is a massive regulatory change and a shift from how things were done to how they're going to be done in the future. And so we have, at any one time at the moment, probably between half a dozen and a dozen different regulatory changes and plan changes going through that we need to monitor to make sure we understand how that's going to impact our clients, which is largely in this context, agricultural clients who are taking and using water, and the associated land use activities with that, such as effluent discharge and intensive winter graze and things like that.
So, what are the issues at the moment that farmers need to be concentrating on?
The most recent one that has come up, and it dovetails with some recent documents coming out of central government as well, is land use controls on storage ponds, intensive winter grazing, and stock exclusion. And so the Environmental Protection Agency notified a plan at the start of July, which outlines some potential controls that could be introduced. And our clients and operators need to be aware of just how those documents dovetail with each other and what their obligations are actually going to be, because they're not exactly consistent in all respects.
So, what are the kind of groups that employ you to do this sort of work?
While you get some individual operators coming in getting some advice, I'd say as a general rule now, our clients are catchment groups, where I guess as the regulatory changes have evolved, it's become more economically efficient for operators to work together, and both environmentally efficient to work together to come to catchment-wide solutions. And so it becomes, what's the point of one operator upgrading their infrastructure if that has no positive effects on the entire catchment water quality? And so that's sort of the way our client base has evolved. So we'll see when we get a big plan change come through that will act for a catchment group as opposed to an individual in most respects.
So they'll come to you and ask how it affects the catchment as a whole.
Yeah, and our experience is that the catchment groups are on top of it. They understand this, and they understand that there is an evolution taking place, and that they need to be involved. Where I think we are slipping through the cracks as smaller operators who don't have any expertise in understanding what these plan changes are, and there are a lot of them at the moment. And so grappling with the resource management process and how that applies to a smaller operator can be difficult. And what we're seeing is reasonably short timelines now to get things done, and whether they're aware of those obligations or not. And in some respects, particularly in relation to the upgrades of storage ponds and things like that are coming up, that's going to require a significant amount of economic backing. And whether they're having those discussions with their bankers and their support, I don't know. It will be a really interesting period of compliance shortly after these 2022, 23 dates come in, as to whether people have actually been paying attention to these or not.
Now, you talked about operators, individual operators. So by that, in our context, that would be farmers, right?
Yes,
Or
that's right.
So if a farmer belongs to a catchment group, can they just sit back and think these sort of issues are going to be communicated to them? Or should they be?
So they'll have a group and a board, and that board's job is to communicate to them. To an extent, we don't want too much to do with those personal relationships between farmers, because as you can imagine, a lot of the time the tensions are high, especially when it comes to water rights. And so we work with other consultants who are brilliant at managing those relationships. And it's such an important part of the role, because if you give up water at the top of the catchment, then someone else gets it at the bottom, and vice versa. And so there are always inherent complexities in how that runs. And I won't go into any details on how that works, but everyone knows that that's just the most important part of making a catchment group work, which is some give and take.
So who advises the individual farmers on those issues?
So you'll set up a catchment group constitution, and you'll have your elected board members, you'll have your chair, and they're the ones who control those decisions. And so you can give advice, and they'll make a decision as to whether they distribute it or not. You'll give them a summary of information, and they'll say, okay, we want to have maybe 5 of us in the room so we can just quiz you on how this is actually going to practically operate. And then they may even bullet point our advice and send it out to the clients. It's just a means of, I guess, filtering the information in a way that their constituents can understand. Hopefully it all goes out.
Now, what about the responsibility of farmers to have farm environment plans?
Well, that's becoming a standard condition on most consents now. And so what we're seeing, and particularly in Plan Change 8 that's just come out, is councils are using best practice methodology to achieve short-term environmental gains. And there are a lot of gains to be made in that respect. And so potentially huge infrastructure upgrades and expensive infrastructure upgrades aren't necessarily required to achieve some environmental benefits. And so that's the purpose of a farm environmental plan, is to ensure that you're using those methodologies, and council have some enforcement teeth to actually enforce them themselves. And so that's the reason for them. The other reason is that it's all about adaptability. And so a farm environmental plan isn't set in stone, and it has the ability to adapt as new technologies become available, and it becomes an adaptive management response. And I don't know many farmers who aren't on board with those, and most of them are all on board with, if the technology becomes available and it's practical and feasible, then they'll implement it.
So most farmers you know of would already have a farm environment plan.
Yeah, most farmers do now, particularly if the ones we are working with often require consents. Yeah. And so it's become a standard part of a consent now, is to implement that farm management plan. Yeah.
So if we were leaving this topic shortly, what advice could you leave with farmers who are listening to this? What do they need to concentrate on the next 1 or 2 years?
The next 1 or 2 years is all about, well, in Otago in particular, is that we are going through an interim period of plan changes. And so for the next 2-3 years, we are having a set of interim solutions to give effect to our National Policy Statement on Freshwater Management. Those changes only have a short duration, but they do have some immediate requirements that you need to be on top of. And so that is my advice, is make sure you are on top of these interim plan changes, because even though they're going to be replaced supposedly in 2023, becoming operative in 2026, it will still have immediate impacts on the way you have to run your property. And so just understanding those obligations is probably my number one takeaway from this discussion anyway.
And those obligations for individual farmers would best be got from their local catchment groups. Is that fair?
Some of them, no. Because with Plan Change 8, they are more farm specific. And so let's say an example is the upgrades of storage ponds at the moment. Plan Change 8 proposes to bring in a requirement for, let's say you have an existing storage pond. If you meet minimum standards, construction standards, then you don't need a consent and it's permitted activity, but you then have to obtain a discharge consent immediately. If your pond does not meet the minimum construction standards, then you have 6 months to 3 years, somewhere in between, to upgrade that pond. And so that's not a catchment wide, that's actually an individual operator's obligation to understand whether they meet those standards or not.
So who's going to help individual farmers do that? First of all, they've got to get a discharge permit. Do they apply to the local regional council for that?
Yes, so
They have to get a civil engineer to come and assess the pond.
yes, so most operators will know, I guess, the construction standards of their pond. The criteria is now found within the regional plan itself if Plan Change 8 goes through. And so being familiar with what document you have to refer to that tells you your criteria, and then having the right expertise available to assess the pond to find out whether you meet it or not. That's the step one that I'd encourage operators to do, is go out, find out whether the pond meets that minimum construction standard. And if it doesn't, then you've got some steps to make.
And the discharge consent?
The discharge consent, so that the requirement on a discharge consent now, it's interesting because under the previous rule in the plan, it was to do with nitrogen discharge. And so that rule, through a previous plan change that just become operative, was extended until 2026. And so there was no requirement for an operator to obtain a consent for nitrogen discharge. What this plan change is doing is saying you need a consent essentially for nitrogen discharge, but it's under the guise of effluent discharge. And so it's a land use as opposed to a nitrogen leachage issue. And so it goes back to that whole idea that council are trying to get people to implement best practice methodologies rather than, I guess, a level of nitrogen leachage from a property. I've just lost my train of thought there for a second.
Derek, it seems to me like when we have new regulations in the financial services industry, we do our best to comply. But then if the Financial Markets Authority audits us and it's not squeaky perfect, then they tell us how to fix it and we fix it. I mean, do individual farmers get some leeway if they're making an honest effort to comply with all these regulations, but after an audit, it's found that there's something being missed? Do farmers get a chance to fix it, or is it completely different when it comes to these sort of issues?
And that will be really interesting to see as we approach 22, 23, when these ponds have got to be upgraded and intensive winter grazing requirements come in, because there's going to be a learning period, and paddocks that you've historically used for grazing will have to be stripped back and used in a much lighter form. And so we have seen councils be cooperative at times as we work through and make sure that best practice methodologies are being used where there has been non-compliance. But that's a discretion for them, because an offence under the Resource Management Act is a strict liability one. There is some defences of no fault, but they're really difficult and it's a high hurdle. And so if they want to prosecute, then they have the ability to do so. And so it's really important that you control, well, you've done all the measures you can to mitigate the environmental damage and things like that, but you've got to maintain that relationship with the council as well, or else they do have the ability to do so.
Right. So consult the documents at the regional council level and talk to the regional council people, get advice in that way, so that not so that you're getting ready for these plan changes. So the Plan Change 8, actually, are you saying it doesn't actually come in until 22, 23? So there's a bit of time.
It stages the requirements for upgrades, is the best way to put it. So if you've got an existing pond that meets the standards, then you don't need a consent for the pond itself. But then if you don't meet the standards, then you have a sunset period. So if you have storage of 10 days in your pond using the storage capacity calculator now in the plan, then you have to upgrade the pond within 6 months, or else you need to obtain a consent or a temporary consent. If you have 40 days storage, then you have 3 years to obtain the upgrade of the pond. And so what they've done is they've staggered it so that they don't receive all of the consent applications at the same time. And it just gives them a little bit of breathing room to achieve that. because it's going to be, there's going to be a lot of consents process from council's end to try and make this work.
Thank you, Derek. Derek, the other thing that I hear farmers talking about are the deemed water mining rights, and the negotiations and discussions around them. Most of the people I talk to sort of throw their hands up in horror. But is this all is this being dealt with at the moment under the plan change number 8, or is it?
No, that is being dealt with under plan change 7. So that has also been notified by the EPA. So that's been called in by the Minister, been notified under plan change 7. And the submissions on that are due on the 17th of August as well. So your opportunity to review that and lodge submissions is coming up. Most parties have already filed submissions on that because it was originally notified by the ORC. People lodged submissions, it was then called in. So most people, or our clients anyway, understand where that's heading. It's been interesting watching that applied in its current form because it's been notified. When someone's processing a consent for a water permit at the moment, it's still got to be considered. And so because it has directive language, it's still given some weight. And so that's going to be a really interesting dynamic for us over the next year or so as that is processed, is how much weight do we give a plan change that's in the infancy of its process, but has really clear language on how you're to approach consents, particularly around duration of water permits.
Oh, well, Derek, I think that's probably enough for now. I mean, it's a complicated area. I can see why they need lots of lawyers looking at this. It's a specialist area, and what you were saying before, that's about 50% of your work.
Yeah, I'd say the regional freshwater plans at the moment is taking up a huge chunk of our work. Thanks partly to the ORC and their previously defunct plan that doesn't give effect to the MPS freshwater. So they're in in stages of incrementally upgrading it and providing interim solutions. And so that is keeping us busy, making sure that those short-term plans or the interim solutions aren't negatively impacting our clients and other operators.
Derek, thank you for your time this morning. It's I think I'm better off. I do know I've got a feel for who you guys work for and the kind of work you do, but the complexity is also a little bit overwhelming. Again, I'm not working with it every day. Farmers, of course, have been talking and thinking about this and getting advice on it over a much longer period of time. So I'm really the baby here. But look, thank you for the article also that's attached to this video that you've done for us on Rule Change 8, is that right?
Yeah, Plan Change 8, that's right.
Yep. And the fact that it's up to 8 rule, I mean, the sky's the limit, I suppose, this can keep on going. Well, look, thank you again, Derek, and good luck for your work and the help you're giving your clients. I'm sure that it's very valuable.
No, thanks for having me, Rhodes. Much appreciated.
All the best.
Thanks.
Bye-bye.
Much appreciated.
Thank you.